mean that the NCAA or the member institutions would not be vigorous in providing procedural rights. I teach constitutional law.
In fact, I thought the NCAA was formed in 1905 to protect and promote the interest of college athletics and to encourage participation in it, not to wall it off.
Precisely. And I teach constitutional law. I am certainly a fan of intercollegiate athletics, both men and women, both revenue and non-revenue. But I value my professional interest in the Constitution and in civil liberties generally, and my integrity as an individual much more than the opportunity to sit at a Nebraska volleyball game or to watch swimmers or to watch a Nebraska football game.
Well, let me ask you this. Do you agree with Justice Marshall when he says, just as in criminal cases, an impartial decision maker is essential to the rights in a civil proceeding, this neutrality helps to guarantee life, liberty, and property will not be taken on the basis of an erroneous or distorted concept of the fact of the law. At the same time, it preserves both the appearance and reality of fairness by ensuring that no person will be deprived of his interest in the absence of proceeding in which he may present his case with the assurance that the arbiter is not predisposed or influenced against him. Now, the finders of fact are all under the regulation and the power of the NCAA, which is the body bringing that action against him, right?
Well, but the NCAA doesn't pay my salary. In fact, when I go to an infractions hearing, I go through major grief because of where Lincoln, Nebraska is located.
But you're not representing to this Congress. In fact, the Lee Commission recommended an independent arbiter of the facts, and the NCAA has rejected that.
Well, it's not quite accurate.
You're not representing to us that y'all go out and get independent hearing officers, independent arbiters of the fact, are you?
No, and what I would say is due process requires a balancing of several interests. Of course, the interests of the individual who is subject to a penalty is a primary interest, but so are the interests in efficiency and fairness, uniformity of treatment.
Cost, in other words, efficiency, cost.
Certainly, we could have a different system for intercollegiate athletics that balanced those rights more, but at the cost of other interests. And we all know that the law of unforeseen consequences sits out there as a looming presence when we start making substantial changes to a process. Professor Roberts, in his written testimony...
All right, let me close by saying that I appreciate that, but I would say I would hope the NCAA would look at who generates the revenue, and it's the student athletes.
The gentleman's time has expired. The gentleman from Indiana, Mr. Hostetler, is recognized for 5 minutes. It's my understanding that we're going to have votes on the floor relatively soon, so I want to keep it moving along. But
thank the chairman. Dr. Ridpath, I have one question about your following on Mr. Jenkins' line of questioning with regard to a new mode of regulating college athletics, and that is turning the situation over to the school faculty. How would that work? The reason I ask is because that would be a voluntary environment. I assume that colleges would voluntarily enter into a new covenant, new compact to regulate themselves, but they would do it as opposed to the regime now. They would do it through school faculty. How would school faculty not bring into this situation a similar bias that is claimed now with regard to the NCAA?
Thank you, Mr. Hostetler. I would direct you to the website www.thedrakegroup.org that details, and I will submit this afterwards, but details our 7-point plan to solving a majority of the ills that confront college athletics today with the faculty as the driving force. It would be incumbent upon individual faculty senates to adopt these proposals. These proposals would ensure that college students are playing college sports. This would ensure that college students, that college athletes are treated as college students. This would ensure that there's no multi-million-dollar academic eligibility mill to keep not just kids who might be academically unprepared to go to college. I think somebody who wants to go to college is the key. But I can strongly disagree with Ms. Patudu. There are several kids, many kids, hundreds of kids, who come to college to go pro. and that is the only avenue right now they have to go pro. Enforcing the great group standards will finally break down the dirty little secret that the NFL and the NBA and the NCAA have right now of forming minor leagues, giving these other kids who have no desire to go to college another place to go. Then therefore you have college students who are interested in going to college playing college sports. Again, I would direct you to the website and our 7-point plan, but I do believe that it's foolproof.
For the record today, and this may be unfair as an example, but are you saying that Colorado University professors, faculty, would determine, for example, if Jeremy Bloom could play college football at Colorado University?
Absolutely. Eligibility decisions at an institution should be the decision of the institution that fits the academic profile. There is no reason, absolutely no logical reason, that Jeremy Bloom was not suited up for the Washington State game last week.
And I'm just wondering, do you think I mean, if a university would determine its own eligibility requirements, because that's what you're saying, essentially get rid of the NCAA rules as they are now and say, if a particular college wants a particular athlete to play, then that college would determine if that athlete could play and defend a national championship or whatever.
Certainly, we advocate, of course, a 2.0 grade point average and meeting admission standards as the academic profile of the incoming class, not bringing someone in who has no interest in playing, interest in going to school, coming in with a 12 ACT score and basically warehoused for a year.
Well, if that were the qualifications of the university, that would be what they would do.
If that was the qualifications of the university, but I don't know too many that do that,
Not today.
very rare exceptions, but they do for athletes, yes.
Right. And then secondly, Dr. Patudo, if I could ask a question with regard to the situation between Tim Dwight and Jeremy Bloom, and all I'm concerned about is the substantive difference, because if I understand it right, with regard to NCAA rules, an athlete can be at amateur status in one sport and be a professional in another sport. And could you just give me the substantive differences? I'm not concerned about what you think about his testimony today or anything like that. I just want to know the substantive differences between Tim Dwight being a professional football and an amateur track athlete and Jeremy Bloom being a professional skier and an amateur football player. What is the difference?
Congressman, I certainly could do it, but I think Ms. Strawley is in a better
That'd be fine.
position to respond.
That'd be fine. And Ms. Strawley, your name for the record, as well as were you also involved in the Tim Dwight case?
Certainly. My name is Jennifer Strawley, and I'm the Director of Membership Services and Student Athlete Reinstatement. I was not actually involved in the Tim Dwight case in 1999. However, the differences between the cases are, in Tim's situation, he asked forgiveness for what was reported as an unintentional violation of NCAA rules. In Jeremy's case, he went through, asked for interpretation of the rules, sought waivers on behalf of our rules through 2 separate committees, and then, under his own admission, knowingly committed willful violations of NCAA rules. Jeremy has referenced in his statement that that's the same as
my time has
Dwight.
run out. My time has run out. So I asked for substantive differences between the two. You've given me procedural differences with regard to asking forgiveness as opposed to asking permission. But what are the substantive differences if the chairman will?
And the gentleman's
Grant-
time's expired, but if
Grant me one additional
you
minute.
can respond to the question.
The substantive difference is a willful violation of NCAA rules and a knowing commitment of a violation of NCAA rules when, in fact, he knew it was against the rules to engage in that activity.
I thank the chairman.
Thank you. The gentleman from Florida, Mr. Feeney, is recognized for 5 minutes.
One of the things I love about college athletics is the passion and the intensity. I specifically love Big Ten football and SEC football. I'm from Florida. This is the first time at the ACC, right? My friend Congressman Forbes wants me to remind how intense that competition is. This is the first time I'm aware it's spilling over into the United States Judiciary Committee, though. And I guess I start with the initial bias that I absolutely believe that there are unfair decisions probably made by the NCAA from time to time, just like the United States Supreme Court made a horrible decision in the Dred Scott case and has made other decisions that I think are horrible and offensive. I think any judicial body is going to be imperfect. But the question is whether or not Congress ought to act. And another bias I have is that I doubt there's any situation that Congress can't make worse if it's not careful. And one of the things I would like to do is to put pressure on the NCAA to find ways to be more responsive if there are serious problems with the way that it enforces its rules. But that's sort of where my bias is. Not here to defend individual decisions that may have been very much wrong. One of the things that I'd like to ask, Dr. Ridpath, you say that the NCAA is a cartel and a monopoly, and obviously they've got a great deal of power. If I want to play collegiate athletics as a practical matter on a very competitive high level, I don't have any choice but to play by the NCAA rules, like it or not. So I do agree with your contention that they have an awesome amount of power. But there are other options for me. If I happen to be a very skilled hockey players get drafted at 16, 17, 18 years old. The same thing with baseball players. A talented football player, 99 times out of 100, maybe more, goes through the college programs first, but and that may be a little bit of an exception. But in basketball, we've got people from the time that Mr. Dawkins was drafted at, 17, 18 years out of high school. So this is not the only outlet for a talented athlete. Like Mr. Bloom himself is actually demonstrably skilled in more than one sport, and if he didn't like the NCAA rules, he clearly had options. And I would ask you whether this is really a monopoly or cartel that keeps people out of, A, pursuits that they want to pursue, but more importantly, livelihood, which would be a problem in my view.
I would say on the surface, what you're saying seems very logical. But again, facts are stubborn things. Yes, hockey players can go pro at a very young age. Baseball players can. Other sports can. They don't generate the revenue that football and men's basketball does. The NCAA and NFL are in collusion to make sure that kids cannot participate in the NFL until 3 years after they graduate from high school, and the NBA is going to try to pursue that same rule. Why? The NCAA wants to keep the best players and generate that revenue, which is their main vital interest. Generate the revenue to pay those salaries.
Well, thank you. And now you've, in my view, implemented, or you've implicated the potential for an individual constitutional right. Denying somebody the right to make a living is a very different question than what we're doing here. Ms. Patuto, I'd like to ask you about whether or not, because one of the issues is whether these hearings ought to be more open. Now, this is a private voluntary association according to U.S. Supreme Court decisions. I think most of us are biased in favor of openness. I'd like to be a voyeur at a lot of key decisions that are made. Does the Buckley Amendment have any implications that would prohibit at times when students are involved publicizing proceedings?
There may well be privacy interests both in state and federal law. The Buckley Amendment, I believe, goes to records particularly. But there are interests like that replete in those hearings. It's, I assume, one of the prime reasons why university hearings in terms of termination and student-athlete disciplinary proceedings are in private and held to be confidential.
Well, and you outlined some of the practical problems with, the 14th Amendment, as I understand it, does not apply to private or voluntary organizations. It does not apply to the NCAA so long as it is, in fact, a voluntary private association and not a state actor. What are the practical effects if a Supreme Court or if Congress would mandate this, for example, but if the Supreme Court says that the 14th Amendment does apply to due process, substantive, and procedural concerns, what does it mean for the practical implications for the recruiting process, academic eligibility, financial aid, competition, and practice limitations? Are we going to have lawyers on behalf of students go in and say that it's too hot to practice, for example? I mean,
Well,
have you thought through some of the potential concerns with guaranteeing due process for every decision that an institution or the NCAA makes?
Of course, and as a professor of a law school whose salary depends on students going to law schools, it's an attractive proposition to create more processes which need more lawyers. In fact, even if the Congress were to determine or to declare that the NCAA is a state actor, none of the processes that are currently being engaged in, I think, would have to change, because I think the NCAA committees exceed what procedural due process requires. Now, but to get to the heart of the question, which is, were additional procedures put in place? Would it change the dimensions, make more formal? Certainly. You put a lawyer in a mix and you always have a more formal hearing. Rules of evidence are created not to expand the information that can be provided to a hearing officer, but to restrict the information that can be provided. It's a highly competitive world, obviously. My congressman can certainly speak to this much more eloquently than I. The notion that an individual school run by faculty, and I am a chaired professor with tenure of my faculty, and can do so in a way that would make institutions fielding teams that compete with teams from Nebraska feel confident that we're all applying the rules in the same way and in the same fashion. It's one of the more interesting notions I think I've encountered in a long time. Recruiting is a highly competitive business. One of the interests that institutions and individuals have before the committee is getting it done quickly. If you're subject to an infractions case at a major university, your ability to recruit is substantially affected. And I assume that every other competing coach in the country is going to say to a prospect, you don't want to go there, you're not going to be able to go to a bowl, they're not going to field a competitive team because there are going to be scholarship losses. That's the world that this is. It is not a world of 200 or 150 autonomously operating institutions and athletics programs that don't have to deal with each other on a level playing field.
The gentleman's time has expired. I was waiting for you to catch your breath there, but I don't think you breathed through that statement. So
I'm from the New York metropolitan area. We don't breathe.
that explains it. And we've saved our best for last here. The gentleman from Virginia, Mr. Forbes, is recognized for 5 minutes, and I believe he will be the last questioner unless another member would show up.
Thank you, Mr. Chairman, and I thank you for calling this hearing and thank all of you for being here. I think, as Congressman Feeney mentioned, we all recognize that all of you are here with good intentions and good motives. We appreciate the good work that the NCAA does, and we also recognize that regardless of good intentions, sometimes decisions can go awry. The difficulty for us is when those decisions go awry, they can have enormous impact. Mr. Bloom has testified that he has perhaps lost a college career and perhaps more. Mr. Ridpath feels his reputation has been lost. And one of the questions, Ms. Patuto, that my colleague from Virginia raised a little bit earlier was in regard to the Hispanic College Fund football game and that cancellation. And I know you indicated that you couldn't respond to that, but the problem we have is sometimes perception becomes reality and individuals look at something and it's very, very arbitrary. We've kind of had a system here we've had today of having people slide up to the table to testify, which is fine because we just want to get the information out. But you alluded earlier to, I think when you were talking to Congressman Scott, that perhaps there was another representative of the NCAA here that had some information regarding that Hispanic College Fund football game and its cancellation. If they are not, or not prepared to testify, I would just ask if they could submit for the record an explanation so that we can look at that cancellation because, as we indicated, they have some harsh consequences. That game, the cancellation of it, cost about $2 million to that college fund, which helps a lot of individuals, and Virginia Tech. And if you're prepared to respond to that, fine, but if not, if you could submit it for the record, that would be.
Yes, and Mr. Congressman, as a member institution that runs the organization, I will say as the NCAA's employer and boss that they will certainly provide that information to the subcommittee.
Good. Thank you, Ms. Padu. And thank you, Mr. Chairman. That's all the questions I have.
Okay, thank you very much. I believe that concludes the questioners.
Mr. Chairman.
Yes, gentleman.
Chairman, I would ask for a point of personal privilege.
Okay, the gentleman would state his point.
Mr. Chairman, I have said all along that my purpose here was to get the NCAA to adopt its own, the recommendations of its own committee, and that was the Lee Committee, and that my interest in these hearings was the student athlete and due process. Despite this, the NCAA has made calls. They've told members. They have brought up the Auburn and Alabama cases. They have brought them up. And then they have said that I was bringing them up. They've said that to, and I wasn't able to prove that till yesterday when they actually put up on their website a description of this hearing today, and most of that description on the website is about the Alabama and Auburn cases, which I consider